Good afternoon, everyone. I'm Vali Nasser, professor at Johns Hopkins SAIS, and it's my great pleasure to welcome everybody to another session in our Rethinking Iran program. This is a series of talks and discussions that we've had during the course of this semester, dealing with US-Iran relations, as well as with internal Iranian development, society, politics, economics. We have had the pleasure of hosting former Deputy Secretary of State William Burns, former Undersecretary of State Wendy Sherman, and Iran analyst Aryan Tabatabai and Ilan Goldberg, as well as we had a session with Manata Hashemi, who works on poverty and social mobility in Iran. And also tomorrow, we will have between 2 and 1 in the afternoon, a session on the impact of US sanctions on Iran's economy, which are results of a long study that have been carried out at the Policy Institute and the Middle East program here at SAIS that focuses on the actual impact of sanctions on Iran's economy. And the first papers that have been published in this series will be discussed tomorrow. So I invite everybody to participate. These are perhaps the very first of actual research-based analysis of the impact of US sanctions on Iran. So tonight, we're very privileged to have with us Professor Arzoo Osanloo, who is an associate professor in the Department of Law, Societies, and Justice at the University of Washington, Seattle, and he's also the director of the Middle East Center at that university. She also holds appointments at the School of Law, Departments of Anthropology, Near East Languages and Civilization, Gender, Women's and Sexuality Studies, and Comparative Religion. She earned her doctorate in cultural anthropology at Stanford University in 2002. And prior to that, she practiced law, having received her law degree from the American University in 1993. Her first project explored the politicization of rights talk and women's subjectivities in post-revolution in Iran. And the results of her research were published in a book entitled The Politics of Women's Rights in Iran, which was published by Princeton University Press in 2009. Her most recent book, Forgiveness Work, Mercy, Law, and Victims' Rights in Iran, which is forthcoming this year, or may have been published by Princeton University Press, is Princeton University Press 2020, is based on 10 years of ethnographic research in Iran in criminal courts in the country, and it's based on firsthand evidence, and that makes it a very unique project. And I have to say, besides working on book projects, Professor Osanloo has also published numerous edited volumes and peer-reviewed journal articles, including in the American Ethnologist, Cultural Anthropology, Political and Legal Anthropology Review, and also Iranian Studies. So we're very pleased to welcome her to Johns Hopkins SAIS and to hear her thoughts and also her findings in this groundbreaking work that she has done, and encourage everybody to purchase the book as well. I'm sure you'll find it extremely interesting. It's a topic that hasn't been analyzed in depth before, and in that sense, sheds very new light on an important dimension of society and politics in Iran. So without further ado, I will hand the floor to my colleague, Professor Narges Bajogli of Johns Hopkins SAIS.
Thanks so much, Vali. I'm very excited to have Professor Osanloo with us today. I learned so much from this book. I first want to just really congratulate you. This is the cover of the book for those who haven't seen it yet. And to congratulate you on this incredible book. I learned so much reading it, Arzoo. And there's so many layers to what you've written here. We're not going to be able to get to all of them within this hour, but I'm really very much looking forward to sort of exploring some of the themes with you. So one of the, I kind of want to get us started into your first book, as Vali mentioned, was on women's rights and the discourses of rights in the women's movements in Iran. And then you went from that project to this one on forgiveness work and looking at the criminal courts. So I want us to, I would love to hear you telling us what made you go from that project to this one. What was sort of the impetus, and also fold in there this question of methods and how you did the research for this book, which I think is really unique, and how you got the access necessary to be able to do the research that you did here, because I think that kind of access and that kind of the methodology that you used really lends itself to this fuller discussion of the criminal court system in Iran that we see in your book. So I would love to hear that.
Thank you. Well, first of all, thank you so much for having this series, which is totally edifying in all of the panels and series offerings you've had so far. And thank you for reading my book and for inviting me to talk about it. I really appreciate it. So to answer your question, the idea for the project came about very organically on the one hand, but on the other hand, I can do like a very quick and easy sort of statement and say, well, that book was about women and discourses of rights, and I mostly looked at personal status law, so I focused on family courts, and I got sort of this angle that deals with family law, family courts, and civil practice, civil legal practice. And then the other half of that would be to look at criminal sanctioning and the gendered components therein. But that's not at all how I originally came to this project. What happened, and a chapter in my previous book is actually somewhat related to how this project got underway. And so while I was in the field doing my year-long, 12-month fieldwork in Iran, it was around this time of year, but it was 20 years ago, and it was 1999. And I was going from interview to interview to meet and talk with people about women's rights issues in Iran. And I was going to government institutions, but as well as private law offices or people's houses to chat with them. And it was the month of Ramadan. And every single person I spoke with during this particular time, all they could talk about was this horrible accidental killing of a young man, a member of the Basij, by another man who was even younger, because the member of the Basij approached him and his group of chums who were smoking during Ramadan and said, put out your cigarette, cut it out. And the fellow who was smoking and his friends got into a scuffle with this other gentleman. And one of the other men, not the one who was actually smoking, accidentally or intentionally cut his jugular vein, and it caused his death. And within a 3-week period, this young man, some said he was 17, which raised all kinds of questions about whether he could be actually executed, even under Iran's own laws and commitments to international law, even back then in 1999. And for this 3-week period, the city, in my mind, seemed to be completely engrossed with this topic, and that's all people wanted to talk about. And they had actually prepared a public execution for this, and they built a scaffolding right in front of the square where this killing had happened. And the indictment, the arrest, the trial, the appeals, all were finished within 3 weeks. And the sentence of qisas had been issued, and appeals were exhausted. I think I said that. And so one day I was at my friend's house, and it was about 4 o'clock, and we were waiting for the azan so we could break fast. And we turned on the television to get that information. And as we did, we saw what we thought it was sunset. So we thought this was like this live broadcast of what appeared to be a public hanging. And this young man was out there in his prison clothing, begging for his life, literally. The previous scaffolding that had been built had been torn down by protesters. And now they had this pickup truck that was holding the scaffolding. And the cameras scanned, there were thousands of people there. And we watched this episode, which we thought was live, unfold. And as the young man was begging for his life, the television journalists were doing interviews on site with people, asking them what they thought about it. Some were for it, most were against it. And suddenly, from that spanning of the crowd, a man raised his arm very dramatically and said, "I'll forgive him." And this was very dramatic. We had no idea what this was all about. And, just because I practiced law and I was like, what? You can do that? That such a thing doesn't even exist. I mean, after this happened, he was taken away. And I forgot to mention that during this period, a lot of international organizations had gotten involved. They had, Amnesty had issued an urgent action appeal. They were questioning the sentence, the legal process. And when this young man's life was spared, Iran has an Islamic Human Rights Commission, and they issued a statement that said, thanks to the humanity and humanitarianism, I can't remember exactly, of Islam, this person was saved. And then there were other quotes from people in the press saying, we don't need Western human rights. We don't need that at all. We have our own system, and ours is based on Islam and Islamic mercy, rahmat. And I became very interested in this issue from, on the one hand, sort of this seemed to be a political staging. My friend and I realized later on that this was actually not live. It had been taped in the morning at sun up, which is when executions take place, right before. But we thought it was, and then I became interested in the politicization of this issue, and sort of, we have our own version of it. We don't need the West. But then from a legal standpoint, I was also very interested because victims have so much more power in that context. Their forgiveness or forbearance, can actually have very important substantive consequences. Whereas in the United States, the jurisdiction where I studied law, that no such thing exists, and victims have some ability to speak to their pain and the impact, often in sentencing, but it is not influential or authoritative in influencing the judge's ruling about the sentence. So that's what kind of launched this interest in this project. Were you going to say something? I can go on and talk about methods, but I just wanted to.
Well, I just wanted to ask you because for me, not having ever studied law or really thinking about this stuff in depth, one of the things that I found interesting about the introduction, and you do a lot of work in the introduction to sort of carry us along as the reader, but this idea of victims' rights approach to law that is apparent in Iran's criminal courts, that you were mentioning in the book is not the case necessarily in a place like the United States where we are and where you studied law. And so I just want you to help us understand that, because I think for those of us who don't know the law very well, for me, it took me a second to wrap my head around what it was that you were arguing in here and the difference between these contexts.
Yeah, I mean, most people who haven't been involved in any kind of, murder situation don't realize this. But I remember when I was in law school and in criminal law, we learned you never want to give the victim the right to decide what the punishment should be, because they just want revenge. So that was kind of my ongoing thinking when I I encountered this idea that the victims have a say, not just have a say, they determine what the sentence should be. So the way it works is, in Iran, I call it an extreme victims' rights approach to homicide. It's not just homicide, but that's all I focus on in the book. So in the United States, we have criminal law and we have like personal law, like personal injury law, which we call torts. And it's true, in torts, it's the person who's injured is an individual plaintiff, but in criminal law, it's the state. And the state brings a case on behalf of the victim. Whereas in Iran, the victim, or in the case of the victim's death, in murder, the victim's nearest relatives, they're considered the injured party, and therefore they hold the right as in a tort. So it's a tort, but it's a tort that is the higher category of legal action. The state also sanctions these, but not as murder in Iran. So it's like I take the O.J. Simpson case. A lot of people are aware of that one. So I take that one as an example. If you remember, the state of California prosecuted O.J. Simpson, but only after he was found not guilty was there a tort case, an unlawful death suit brought by the victim's family. What's interesting there, though, is the state of California has the death penalty, whereas in a tort case in the U.S., only the victim's family can only get monetary, injury compensation. In Iran, it's the opposite. In Iran, the first case you hear is the ostensible tort case, and it's the victim's family that makes the decision, and they actually can ask that the state carry out the death penalty on their decision. If the family forgoes retribution, it's not that the person is off scot-free. There is another hearing, but it's not based on death. It's not based on murder. It's not a murder case. It's not a tort. It's actually a ta'zir. It's a criminal violation, a criminal sanction that is sort of like disturbing the peace, disturbing the public, and the maximum sentence for that, it's a minimum maximum, so it's between 3 and 10 years. But what we would consider the tort is what carries the death penalty, and also what is tried first. And the reason for that, according to Iranian scholars and judges and lawyers, is that they consider the first injury to be to the family of the victim. So it's the family of the victim that has priority in dispensing the punishment.
Got it. And so throughout the book, you divide the book into these two sections. You have the first section, which is on the courts themselves, and you focus a lot on the judges and the roles that they play, and what sort of, you take us through what happens in these criminal courts. And then in the second half, you focus on, I think, who you call forgiveness workers, those who do the work of this cottage industry that you sort of lay out for us. And so, getting to the question of methods, both how you did the research in the courts and through these cottage industries, and then sort of zooming out from there, you make this argument in your book that the system, the criminal court system, is both it's a combination of both ambiguity, because it's not formalized how this process plays out, and it's full, because it's many times about murder, it's full of affect, right? You use affect a lot in affect theory a lot. So it's this combination of both state ambiguity and sentimentality. And that what struck me in this is that I also in my research saw a ton of ambiguity and ad hoc natures of structures, state structures in Iran. And I would love to hear your thoughts about and thinking out loud with you about what this ambiguity at the heart of state institutions means for things like the criminal courts and justice more broadly in Iran, and also for the power and longevity of these structures and institutions, when ambiguity seems to be baked into the heart of many of these state structures and institutions in Iran.
Thank you for that question. So yeah, the book is divided into two sections. The first section is called Crim Torts, where I kind of lay out this, what I understand to be the legal system, and I take you through some of the legal process, because I'm somebody who thinks that legal process is as important, if not more, than the actual sort of substantive black and white law, black letter law. And then the second part is what I refer to as the life world of forgiveness. So you have the law that creates the system, and then the second part looks into the system. And so you mentioned the cottage industry. So the argument that I make is that based on the mandate to be merciful and compassionate, which is then tethered to the legal codes, or the legal codes are tethered to this mandate. There are no, I shouldn't say none, but there are very few guidelines. So on the one hand, the law, the society, the discourse around murder cases is one where people should be merciful and compassionate. However, there is very little guidance on how to be merciful and compassionate, how to achieve forbearance. After almost 35 years, the criminal laws were finalized for the first time. In 2012 for the substantive criminal code, the penal code, and in 2015 for the code of criminal procedures. And therein, for the first time, you do see some guidance, especially in the code of criminal procedure, to judges to try to reach a settlement short of qisas. So you sort of see that amplified, as they refer to it as porrangtar shod. They sort of colored in the legal codes to make these obligations much more salient, much more legible. And but they say they have been doing this all along, all these years. They try to bring the parties to some kind of settlement, sol va sozsh. And what I suggest is that, so there's this duty, an imperfect duty on the part of the judges, lawyers, actors, whatever, and even the aggrieved, the victims, to forego retribution. But there are no guidelines for how they should do that. And I argue that this is a productive tension. When you put this duty, but without any guidelines on how to carry out this duty, bring it to fruition, you have a productive tension. And it's in this productive tension that we have seen this burgeoning cottage industry of forgiveness work that has emerged. And by forgiveness work, I refer to, I'm sorry, by cottage industry, I definitely refer to the sort of the business nature of this. I also refer to sort of this small, unique way that it's carried out, that informalities involved in this term cottage industry, but also, there are transactional offerings and goings on as well throughout it. So at first, when I was doing the research and I would go to the courts, and judges would say to me, so what did you find? Do you have any advice for us? And I didn't know if they were just joking around, like kind of checking out what I was saying, what I would think. I thought, well, if I were like a political scientist and I was trying to come up with some kind of model, I would say, well, maybe you need to have more, strict guidelines of when to do this forgiveness work, when not, how to do it. And then I thought, actually, as I learned more, I sat in on more cases, especially in the second part of the book, or I just read like some of their criminal law textbooks, or even just some of the work of people like Wael Halaq, who have written about similar things in, different periods. But even, I should say, like in psychological texts. So like the idea of reconciliation, bringing about reconciliation, cannot be brought about in a very rigid 1, 2, 3 step way. It really has to be tailored to the people involved. The idea that you would hurry it along, or the idea that, anyway, you would have rigid guidelines is sort of antithetical to the practice of forbearance. And so what I learned was the lack of guidelines is intentional. It's not an afterthought, like, oh, we haven't figured this part out yet. No, that it's exactly intentional, and it's left open. It's not only left open because you need this to forgive, but because all of the state actors that I ever talked to were very clear on one thing, and that is that they protect the right of the victims. And they are not going to intervene in that right in any way. And so it's very important for them to remain as sort of impartial or neutral observers, where they can help, but they don't want to look like they are trying to persuade one way or the other. They really want to be neutral, and they really want to be there to help resolve the dispute. And this is one way that the sovereign maintains authority and legitimacy and power, by saying, I have a monopoly on legitimate violence. You can't take violence into your own hands. Everything that's done has to be done within the parameters that I have sort of instituted. And there are even provisions in the criminal code that if you have a ruling of qisas, but you go and kill the person, then you will be subject to qisas. The qisas has to be taken out within the parameters of the state's penal system. What does this mean about longevity? I think I spoke a little bit to power, why it's important. But in terms of longevity, I'm not sure. I mean, I think it's just, it's really important to allay the concerns of victims, that they will get justice. And this is one way that the state is trying to tell people that they will get justice. So I'm not sure if I answered that question adequately or not.
Yeah, I mean, you did touch upon something in your response, which also comes up over and over in the book, which I found super fascinating, is the importance of time, and the importance of giving the victim's family time to think about, do they want retribution or will they go for forbearance? And how not only, and how the judges themselves actually try to prolong time, and how in that interim period of constantly, it seemed like, putting things off into the future, there was an opportunity for that forgiveness work and that cottage industry to come to life in that period, and try to convince the folks in the victim's family about forbearance. And so I would love to hear a little bit more, or I would love the audience to hear a little bit more about this concept of time that you sort of weave in here, and how you show us how during the trials themselves, the judges, take on their formal position of the judges, but then they very much, in a very physical way, change where they are. They come down to where the victims' families are. They, and they themselves seem to, and correct me if I read this wrong, but seem to sort of become advocates for this, for forbearance. And as you're discussing that, as you're sort of thinking and answering that, also, if you could because I was also surprised by this in the book, but talk about how many I mean, you did mention how difficult it was to quantify these kinds of cases in Iran, and how to know how many actually end up in forbearance because of the amount of time that it takes for these cases to play out. But if you could give us a sense of, I mean, I was surprised that this was like more than half of cases end up like this, criminal murder cases end up like this. So also give us a sense of the scope that we're dealing with in what you're writing in your book, and then how this process of time sort of plays out.
Thank you. Well, I have a whole chapter on time, and it was the last chapter I wrote. And each chapter of the book kind of looks at one set of characters: judges, lawyers, social workers, actors, like. And after I was done with the book, I thought, wait, time is actually an actor. It's a character in the book. Time is so important. In actually all of the chapters, I felt like I just needed to spend some time to explain the way that time works and the way various forgiveness workers, including judges who are very powerful, manipulate time for the very reason that they need to give families of victims time to heal. So I don't want to skip over time too much, but so time is extremely important. Judges take a lot of opportunity to prolong the resolution of a case. They summon both parties to come and to talk to them. None of this is written anywhere. It's not in the penal code, nothing. They try to get the parties in a room to talk to each other. People will go and visit with them. So all of this extends the time. Cases will sit so that if the judge in the implementations unit who is charged with carrying out the sentence knows, if that judge knows that there is something afoot, there are people talking, then that judge will delay and delay and delay. So they use time as an ally for forbearance. The judges' persona as judges, this is a really important point that you have pointed out, that it's so important to the judges for their own credibility, authority in the courtroom and out. Because in Iran, I don't know if you know, like, there seems to be a lot of like celebrity judges. Like there are movies made, like there's movies made about judges. They are on television. Like, so they actually have very important roles beyond the courtroom. And this one case that I think you might be referring to, there's a physicality. There's a very important shift that happens between when the judge is being the judge and when the judge is transforming himself into a mediator who is now tasked with bringing about a settlement short of qisas. And they try to demarcate that in every way possible, with their voice, with their words, with their rulings, with their statements, but also physically. So the judges are usually on an elevated platform. There's 3 of them in a murder case. And here they are, the impartial trier of fact. And they ask questions, they issue rulings, they are judges. And in those circumstances, the judges do always, at the very start of the hearing, ask the family of the victim, who are the plaintiffs in these cases, what do you want? And even in that initial interview, if you will, they try to say, if the person says, well, I want qisas, and oftentimes that's what they say, especially at the beginning, nothing else, just qisas. They say, but you have these other choices. Do you even know what they are? Let me explain them to you. Why don't you think about it? Do you want to take some time? Why not use time to think about it? You're not going to lose this right. This right of forbearance is yours forever. But why use it right now? You can use it later. So that's another way they use time. But then the most important thing in that hearing is that they be perceived as impartial. And the most important thing that they do is protect the process that the state's authority rests on, but also to protect the right of the victim, the right to have that qisas. The moment the ruling is issued, the judge can shift to become a mediator, mianjigar. And I saw this many times, but in one particular case, literally, one of the associate judges jumped off the stage, the platform, raised his hands and said, now we are in the jalseh solusazej, the resettlement and compromise meeting, or the settlement and compromise meeting. Another judge made a very swift demarcation by saying, the hearing is finished. Now we are starting the reconciliation hearing. And you can also see a complete shift in the judge's tone. You can see a shift from being this authoritative, scholarly, kind of harsh at times spokesperson representing the state to now becoming kind of like a soft-hearted elder sage, if you will, Rish Safid, who now is saying, listen, why don't you guys talk to each other? You know, speaking in a totally different tone, speaking in a persuasive manner, even, like I said, shifting, no longer on the elevated platform, now down in the courtroom among the people. So there is a very important shift that goes on from being the judge to the mediator. And I think it's important for the judges to mark that. We're no longer in that legal hearing aspect. We're now doing the informal forgiveness work. So you wanted me to add to that and say something about, I forgot.
Well, I mean, just talking, I mean, well, maybe let me rephrase what you're bringing up here is, and this kind of leads into the next question that I have, which is, you know, the process that you outline and sort of forgiveness work within the courts, criminal courts in Iran, is so counterintuitive to how one hears about and knows about what happens in Iran's courts, and especially you're talking about criminal courts, but in general on executions, on political prisoners, on things like that. So how does the research that you did, the stories that you're painting for us, where does it belong in this broader sort of canvas of both what is known in the public in Iran and outside of Iran, and sort of the realities of what we see from what goes on there?
Yeah, thank you. So this was the question about, like, is this a rarefied aspect of what goes on in Iran? And so yes, this will be a nice segue from, is this like I have a section in the introduction is like, is this a thing? Is this a thing? Or is this just this like rare thing? And then maybe I can get into a little bit about the methodological part. So while I was doing this research, it really occurred to me, but also people in the United States would ask me, well, how frequent is that? Like, why are you even studying that? I mean, it just sounds like it would never happen from the perspective, and that's really interesting from the perspective of people in this country who's, when there is no like victims' rights, I guess victim can't really have a lot of impact. It's interesting, they would say, well, why are you even studying that there? Because I'm sure it never happened. So there's also kind of this foregone conclusion about what goes on, what can go on based on experiences here, which are based on completely different legal standards. So I was very surprised. It's very hard to get statistics about this, in part because they say there's no sort of like centralized statistics on this. These are all like local. I'm not sure. There might be a centralized statistic. Maybe there is now. There wasn't back, when I was doing the research. But what we do know is that there are a lot of anti-death penalty groups, some of them Iran-focused, outside of Iran that actually do keep track of executions, and people from inside Iran report to them. So they even report on ones that were not publicly known. And they have running tallies. Amnesty does, Iran Human Rights Organization, I think it's called, does, and it's their statistics that I cite in the book. But in addition to that, I did ask a lot of members of the judiciary, and it was finally when I was in the implementations unit in Tehran, where the judge literally, he said, he called, so he was the implementations judge, his office was on the top floor, and he got on the phone. There are 5 units or divisions within the implementations unit, and he called his magistrates, his judges in each of those divisions, and he said, bring me your statistics for the previous year. And one by one, they brought them up. And he had these sheets of paper, and I was like salivating. He said, I'm not going to give you these, but I will read off to you what they say. You can write it down. So I did. I wrote them down. And the statistics that he gave me, and they were just for his office, his implementation, which covers Tehran, it was 2/3. And when you look at what the Iran Human Rights Organization has since 2015, 16, 17, I think I put 4 years in my book. It's very close. There are some years it's closer to 2/3, but some years it's just above 50%, but that's where it's hovering.
And that's the statistic, just to clarify, of cases that go to forbearance, that are forgiven.
So what they give, the numbers are, the 2/3. Yes, sorry, that's very important to clarify. 2/3 of victims who have the right to seek qisas forego it in murder cases, yeah.
So then the death penalty is not carried out in those cases.
Exactly, right.
So then so from what you just laid out, then how does this relate to questions of forgiveness work versus activism?
That's a great question. Yeah.
You know, you do a really interesting job. I want to talk about forgiveness work versus activism, but then from there also think with you about, because I love in your epilogue and your conclusion where you talk about human rights versus humanitarianism, and it goes back to our a point that you made a little while ago about the monopoly of the state over violence and sanctioning who gets to live and die. Yeah. And so but let's start with the question of forgiveness work versus activism, and this question of those who are involved in the cottage industry of forgiveness, versus or vis-a-vis those who are anti-death penalty activists, either internally or some of these human rights organizations that do very important work that you were talking about externally. So how do we map these out? How do we understand them?
Oh, thank you so much. I think that's like my most important finding. Before I do that, I just want to say one quick thing about the methods, because I've been trying to answer that and I feel bad if I didn't. But the last question about statistics and how I got them from that implementations judge is actually it says a lot about how I got access. And maybe it'll even go into this question about forgiveness work versus activism. So the implementations judge, his name is Shahriari, and he is, he's a tough guy. He executes people for a living. But he also is an intellectual. He was getting a PhD. I think he's gotten it by now. And when I went to his office, it was my 3rd try to get an interview with the head person in that office. They had changed 3 times in 3 tries of mine. But by now I had a good set of commendations from these judges in the criminal court who sent me to this office. And he said to me, and he's a young guy, and he said to me, who are you? Are you an activist? Are you a journalist? And I'm like, no. I said, you know what though? Everybody already knows about your executions. Like, that's not new. That's not even considered original research. Like, I'm not going to get anywhere with my research if I just repeat what everybody already knows. I said, but what people don't know is about the forgiveness work. Nobody knows about that. And not only does nobody know about that, but in America, they don't even have that. They were like, what? So that was actually the thing that got me access 99% of the time with the judicial officials, because they thought that I wasn't trying to expose them. I said, I don't need to do that. Like, everybody already knows. And second, they thought it was really cool that they had something that we don't have in America. So that's the access question. Now, same thing. Shahriari says to me, are you an activist? Like, why would that bother him so much? So throughout my research, I encountered people who kind of walked this very fine line, mostly social workers who were not personally involved in a murder case. They weren't family a victim or anything, but they were just like, would go around and try to talk to people, and they called themselves social workers. And then there were these people who, over the course of my doing research, I met them, I interviewed them, they were sent to jail. And you know who I'm talking about. And I thought, that's so bizarre. Like, these people are really doing the same work. So what makes one group of people who's trying to get the, death penalty spared different from another group that's trying to get people spared from the death penalty? And the difference is, and this is something that the Islamic Republic of Iran is very, very sensitive to, they see one group, anti-death penalty activists, as challenging the system. The system is based on Sharia, as they interpret it, and to challenge qisas, which is so foundational to them, it's in the Quran, is a challenge to the entire existence. It is an existential threat. Forgiveness workers, what they're actually doing is using the system's capacity to advance forbearance, to spare people. So it's kind of a fine line, but what's really important here is how the state perceives of these different individuals. With forgiveness workers, there are times that they actually work with the forgiveness workers. All the forgiveness workers have Shahriari's phone number. Shahriari, and these are like lay people, many of them from, Balai Shah, from northern Iran, the more well-to-do, less, I guess, openly pious. And but they work together on these issues. And I think one of the reasons it works is, I go back to how we started this session with that article that I wrote, and the father who puts his hand up and says, I forgive him, and the Islamic Human Rights Commission who says, we don't need the West human rights because we have Islamic human rights in mercy. And I actually wrote, I didn't realize this at the time, but the first article I wrote about this back in 2006 is actually where I ended up here. And that is to say that there is a very big chasm between rights-based discourses and, death penalty, anti-death penalty activism that is fighting for rights, human rights, versus a discourse that is based on forgiveness, forbearance, mercy. Mercy is a humanitarian response. It re-entrenches the hierarchy. It maintains and entrenches the hierarchy. At the top of that hierarchy, of course, is the state. Human rights is a challenge to the state insofar as it's asking the state to refrain or to respect or to do something to make the subjects of the sovereign somehow more on par with the sovereign, or at least equal among themselves. And I think that it helped me to really think about what is at stake for the state, for the Islamic Republic, with these human rights activists, and what is at stake for the activists themselves, that they are risking their lives and years, and in some cases decades in prison, when they could just be doing forgiveness work. But I think there's something much bigger that they're advocating for, which is perceived as an existential threat to the state. Humanitarianism versus human rights, equality versus hierarchy. Does that answer your question?
Yeah, very much. And I mean, in that dichotomy, or in that fundamental difference that you lay out between mercy, seeking mercy versus rights, and human rights versus humanitarianism, I think is that tension that is at the forefront of so much of politics today, whether it's in Iran or as we're seeing increasingly in other parts of the world as well, where it's, do you ask for rights that the state should give you, or are there rights that you demand from the state? And how these, and what you do really well is that or what your case that shows us is that within the confines of one that's not a radical critique to the state allows it. Now, whether that is something that should be is something that activists or citizens strive for or not, it is fundamentally a philosophical and a moral question about citizenship and how we see our relationship with the state. But it shows that within the confines of the state in Iran, at least, the mercy is something that they will live with, and oftentimes it seems like, at least with some of your judges, even welcome and work towards, but ultimately it reinforces their power. And it was that entire conversation, or that entire sort of discussion that you had towards the end, I found really very generative to think through. And we only have a few minutes left, and I have a whole few more pages of questions I want to ask you, but I want to get to one in particular, which is gender runs throughout your book in various manifestations, from your role as a researcher, from gender roles in forbearance, questions of honor. The parts that I loved so much were the role of the mother, both the mother of the victim and the mother of the perpetrator, and how oftentimes it was this relationship between the mothers that then led to the forbearance. And then broader questions of Javan Mahdi and Imam Ali that you bring up, and so it's a big question, and you deal with it with so much nuance throughout your book. But just if you want to say a few things about the multitude of ways in which gender and gender roles sort of come up through your case and your analysis.
Oh, thank you for that. And I'll try to keep this one short because it's very vast. But one thing that really surprised me, I don't do quantitative research at all, but it's really hard not to quantify the fact that in almost every single case, it was the mother or some designated female matriarch who all of the immediate family, because every individual who's an immediate relative to the one who died has a personal and individual right to qisas. And what shocked me was in almost every case, they would designate the mother or the sister or some female who was a matriarch to make the decision for them. And on the one hand, we could say, wow, that's really empowering to the matriarch. But when I talked to them, I thought a lot of them were like, it's a terrible burden. However, it's like just yet another way in which women have to do this labor. And women, a lot of them are the forgiveness workers at the same time. And as you pointed out, they're also the mothers that are mother of the victim and mother of the perpetrator would be, executed person. And their conversations were really, really important. And when I asked one woman her why, so again, she's in the chapter 5 or something, and I asked her, so this woman, her daughter-in-law, so again, killed her son, and her entire family just told her to deal with it. And I said, well, how do you feel about that? And she said, it's a terrible decision, but my husband said, I'm the one who carried him in my womb. I should be the one to make that decision. And the word womb, rahem, shares a root with the word rahmat. So there is, I don't want to go too far in making this claim, but there is an association with the gender of the womb, female, and the one who is merciful. Although, as Naga, as you pointed out, we have other iconic examples of mercy in the masculine role, but not as sort of the pained victim, but the chivalric leader is the Javan Mard. And the example is for many people in Iran that I talked to was Imam Ali. So it runs throughout in that way. There was one other comment I wanted to make about gender, but now I forgot it. Oh yeah. And as much as women are implored to forgive, when women are the perpetrators, we see much less forgiveness, forbearance in those cases. When women have perpetrated murder as a result of a relationship gone bad or something, we rarely see the family of the victim in that regard being so merciful. And I think there's a lot, if you can go back to the old honor and shame literature, I think that it plays out in similar ways. But my argument, it has to do with the way that the law has been codified and allows for that, for honor to play a very important part in these cases. Killing someone for honor, and they're actually enumerated in the penal code, is a defense to a murder, to a qisas crime. So it reinforces not just honor, but also the gendered effects of honor within the society. Oh, we're out of time.
Yeah, I know. I was just about to say I'm really bummed we're out of time. But I highly recommend it just came out a couple months ago, Forgiveness Work, Mercy, Law, and Victims' Rights in Iran by Professor Arzoo Osanloo. Arzoo, I'm serious. I learned so much reading this. And I think there's so much layered in here that I think we're going to all be going back to it over and over again. And it will take many reads through to fully appreciate everything that you've done and the arguments that you lay out and all the research that it took you to do this. So I really appreciate the book. I appreciate everything I learned from it. And we really thank you for your time and sitting with us and talking through it here.
And I thank all of you who are out there in the world. I can't see you, but thank you for being here. And thank you, Dr. Vali Nas and Naga.
This was very enlightening. Thank you very much. Fascinating conversation.